Welcome to the deep dive. Today, our mission is sharp and specific. We are cutting straight through a complex narrative about public integrity and accountability in Monroe County, Wisconsin. We have a stack of sources here that reveal what we've termed the integrity paradox. This isn't just about, simple mistakes. It's an exploration of how a system designed to uphold the law fundamentally failed, it seems, to apply that law fairly to its own officials.
That's right. And the paradox is really striking when you look at it. On one hand, you see this highly visible success, an award-winning office no less. But when we actually look closely at the internal machinery of justice, especially how that office managed police accountability and transparency, well, the sources reveal some pretty serious systemic weaknesses.
Yeah.
Our goal today is really to look past the accolades, past the awards, and focus intensely on where that internal structure failed behind the scenes.
Yeah.
Because it seems like it created an environment just ripe for an accountability crisis.
And the striking contrast here, it really centers entirely on the former Monroe County District Attorney Kevin D. Croninger. We have to start, I think, at the highest point of public validation. In 2020, he was named the Wisconsin Prosecutor of the Year by the Wisconsin District Attorneys Association.
Which is a huge deal.
It's a significant professional honor. It's public acknowledgement of, dedication and successful prosecution.
Yeah, it speaks volumes about his effectiveness, probably in conviction rates, maybe political success within that professional community too. It definitely established an image of, let's say, exceptional judicial leadership.
But then, just 4 years later, that image it's fractured, seriously fractured. By 2024, his office faced intense scrutiny. And not over, failed cases against everyday criminals, but over systemic failures in managing its partnership with law enforcement.
Right.
The core issues were a lack of rigorous oversight, profound shortcomings in how they tracked police credibility, that absolute critical Brady List issue we'll get into, and maybe most damagingly, the failure to prosecute clear, documented cases of alleged official police misconduct.
So the award reflected the external success, the public wins. But the scrutiny reveals what looks like internal rot. We see a system where, according to these sources, organizational standards were dangerously low, and discretionary power was allegedly used to shield certain individuals.
And exposing that is vital, isn't it?
Absolutely. Because when the very people responsible for enforcing the highest standards of a law are not held to those same standards themselves, public trust isn't just chipped away. It can collapse entirely.
Okay. So to structure this deep dive for you, we're focusing on two distinct but definitely interconnected areas of failure that came to light in Monroe County. First, we'll analyze the systemic weakness in tracking officer credibility, specifically the loose protocols around the Brady List.
The structural flaw, basically.
Exactly. And second, we will dissect the specific and frankly egregious failure to enforce accountability in the alleged official misconduct case involving Chief Rhines and Officer Wooten.
Okay, so by detailing the structural risks in Section 1 and then showing how those risks arguably manifested in the decision not to prosecute in Section 2, we can build a pretty clear case for why the operations of the Monroe County DA's office really demand this kind of exposure. It illustrates precisely how a lack of transparency and standardization can create a mechanism where power might be misapplied, allowing officials to operate outside the normal rules of the law.
Okay, let's dive into Section 1 then. The prosecutor's office and the credibility tracking issue, that systemic flaw. This gets a bit heavy on procedural law, maybe, but it's absolutely crucial for understanding the constitutional obligations at stake here. We're talking about the bedrock constitutional duty derived from Brady v. Maryland.
Right, that 1963 Supreme Court ruling. It's fundamental to due process in the U.S. It mandates that the prosecution must turn over all evidence favorable to the defense. And the critical extension here, which often comes up under the name Giglio, confirmed that favorable evidence absolutely includes anything that could impeach the credibility of a government witness.
Especially a police officer.
Especially a police officer, yeah. They're on the stand all the time.
So if an officer has a documented history of, say, lying under oath, falsifying reports, committing serious on-duty misconduct, or maybe facing internal discipline for dishonesty, that information is basically constitutional gold for the defense, right? And the prosecution must disclose it, no question.
It's the ultimate constitutional safety net. That's a good way to put it. If a prosecutor fails to disclose known integrity issues about an officer, that's a Brady violation, it undermines the entire trial process. It routinely leads to overturned convictions, sometimes even dismissals of charges altogether. The prosecution simply cannot put an unreliable witness on the stand without the defense knowing exactly why that witness might be unreliable.
So this Brady list, or whatever you call the tracking mechanism, it's arguably the most critical organizational tool an ethical prosecutor's office possesses. It should be standardized, rigorous, non-negotiable. So how did the district attorney's office in Monroe County, under this award-winning DA, handle this vital constitutional safety net?
Well, according to our sources, this is exactly where the structural problems began. Monroe County apparently did not maintain a formal, centralized, county-specific Brady list. And that's the standard procedure for many, probably most, proactive jurisdictions.
Really? No formal local list?
That's what the sources indicate.
Yeah.
Which immediately raises red flags, right?
Yeah.
It suggests a lack of organizational commitment to transparency and, frankly, to rigorous compliance.
Okay, so if the DA's leadership didn't institutionalize the process locally, if they weren't tracking officer credibility right there in Monroe County, what system did they rely on?
They relied on a statewide database known as Protect.
Mm.
Now, we need to be clear about what Protect is and, maybe more importantly, what it isn't. It's often run by the state's Department of Justice or a similar state agency, and it's primarily designed to track major formalized disciplinary actions. Think felony convictions of officers, state licensing revocations, or formal decertification from policing entirely. The really big stuff.
Okay, the big career-ending stuff. So what's the inherent risk of relying solely on that broad statewide system?
The risk is specificity and localization. Protect is designed, as I said, to capture the absolute highest level of misconduct that results in a formalized state sanction. So it is inherently limited in capturing localized integrity issues that maybe haven't reached that severity but are still crucial for Brady.
Like what kind of issues?
Well, we're talking about critical material like, say, internal department findings of dishonesty that led to a suspension but not termination. Or maybe a pattern of sustained citizen complaints regarding bias or excessive force. Or even just local administrative findings about untruthfulness that absolutely still trigger the Brady duty to disclose, stuff the state system might never see.
I see. So the statewide system tracks the major formalized sanctions of really big headlines, but it misses the more subtle, maybe, or localized integrity failures that still absolutely matter constitutionally. A local DA's office is obviously going to be far more aware of the credibility, the reputation of its local officers than some massive statewide system could ever be.
Precisely. And this leads us directly to the core structural flaw the sources really emphasize here, the problem of individual discretion. Without a mandatory, centralized, countywide tracking system, one that's enforced by the DA's leadership, the constitutional duty of disclosure fell entirely to the individual assistant prosecutor handling that specific case.
That raises a significant question, though. Couldn't a good defense attorney, or maybe even the DA's office itself, argue that just relying on that statewide system is still constitutionally sufficient, legally speaking, as long as the prosecutor checks it for each case? What did the sources say about that specific defense of the system?
That's a fair point, legally. But the sources seem to focus less on the bare minimum of constitutional sufficiency and more on the organizational failure. The real issue here is compliance assurance. How do you guarantee it happens every time? Imagine a busy assistant DA juggling, say, 100 cases. Many involve minor charges, but still require multiple officer witnesses. Without a standardized, updated local list handed to them by leadership, they have to individually remember to check the external Protect database for every single officer, every single time, and then interpret whether the information they find, or maybe even just local courthouse gossip they've heard, constitutes Brady material that needs disclosure.
That sounds incredibly risky. The whole system introduces monumental risk. Constitutional compliance becomes a matter of individual diligence, individual interpretation, even individual memory, rather than an institutional mandate enforced from the top.
It's basically a cascading failure waiting to happen. What if a prosecutor is just sloppy one day? What if they're completely overworked and just forget to check an officer whose name they see all the time? Or what if they knew, maybe just anecdotally, that an officer lied in a previous internal affairs investigation, one that never made it to the statewide database?
Right. That vital, localized information just gets lost.
It gets lost in the reliance on individual memory and subjective interpretation. The system lacks redundancy, it lacks standardization, which suggests, unfortunately, a culture that perhaps prioritized convenience or maybe plausible deniability over the rigorous constitutional compliance you'd expect, especially from an award-winning office.
And if something does go wrong, if there's a Brady violation, it becomes much harder to expose a systemic fault, doesn't it? The DA's leadership could potentially just point to one individual assistant DA and say, well, they made an error in judgment or interpretation.
Exactly. It creates plausible deniability for the leadership, yes, while potentially sacrificing procedural integrity along the way. When you are the chief gatekeeper of justice, especially in an office led by someone recognized as Prosecutor of the Year, you should really have the most robust, redundant internal checks possible. Things like maybe requiring supervisory sign-off on officer vetting for serious cases, or maybe conducting quarterly reviews of local internal affairs reports to proactively update a local list, which some neighboring counties actually do.
So they weren't doing that kind of proactive checking.
The sources suggest not, leaving such a critical constitutional duty largely to the subjective discretion of individual staff members, rather than making it a top-down enforced standard. Well, it suggests a profound failure of organizational leadership.
Okay, so if the system relies so heavily on individual discretion to prevent constitutional crises, what happens when that same discretion is applied, potentially, to protect high-ranking officials themselves?
That is the absolute perfect segue, because the theoretical risk we just described, this high reliance on discretion, the lack of standardization, that is exactly what seems to have set the stage for the deeply concerning enforcement failure we're about to see in Section 2.
Okay, Section 2. This is the case study that took this systemic risk, this potential for failure, and turned it into what appears to be a clear, tangible accountability failure. The dishonesty involving Chief Rhines and Officer Wooten. This is where we move from procedural weakness, the system flaw, to a specific decision or non-decision to forego criminal prosecution.
Exactly. This incident, which happened back on September 28, 2019, is a perfect illustration, according to the sources, of how that lack of standardized rigor potentially allowed officials to be shielded from the kind of consequences faced by the average citizen.
All right, let's detail the incident itself. We have Officer Grover Wooten, who is a part-time officer with the Village of Ontario Police Department. He crashed his marked patrol car near Johnson Street in the village of Cashton.
Okay. And Officer Wooten immediately provided the initial cover story. He claimed he swerved to avoid a dog, which caused him to lose control and crash the vehicle.
The classic phantom dog defense. You hear that sometimes in accident reports, don't you? Seems like a common trope when someone's trying to cover something up. But the lie didn't hold, did it?
No, it didn't. Wooten later admitted the truth. There was no dog at all. He had actually fallen asleep at the wheel. Reportedly, this was after working a long shift, possibly related to an Oktoberfest event nearby.
Okay, so falling asleep at the wheel of a patrol car, that's obviously a serious lapse in safety and judgment. That's bad enough.
Yeah.
But the invention of the story, the intentional lie to investigators, that's the real integrity breach here, isn't it?
That's the core issue. Accountability should have been mandatory just for that. But the situation apparently became far graver with the alleged involvement of his chief.
That's right. Chief David Rhines, the Village of Ontario police chief himself, became the subject of investigation because he was implicated in allegedly advising Officer Wooten to stick to that fabricated story about the dog.
Wow. Okay, that changes the entire dynamic, doesn't it? This moves the issue from one officer's perhaps momentary panic and subsequent dishonesty to the highest-ranking officer in that department allegedly orchestrating a deliberate cover-up, obstruction of justice, and fabrication of evidence in an official investigation. That is a massive ethical breach and, frankly, a profound betrayal of the public trust by leadership, if true.
So a subsequent investigation followed, and crucially, it wasn't handled internally by Ontario PD, was it?
No, and that was the right move. It was handled externally by Monroe County Sheriff's deputies. They recognized the inherent conflict of interest in the Ontario Police Department investigating its own chief for something like this.
Okay, and what did the sheriff's investigation find?
Well, the Sheriff's Department did its job. They investigated their colleagues in the neighboring department and concluded that there was probable cause for criminal charges. They formally recommended criminal charges against both Chief Rhines and Officer Wooten for their actions related to this cover-up.
Okay, probable cause. That's the standard needed to file charges. What specifically were the sheriff's deputies recommending they be charged with?
The referral recommended misdemeanor charges, specifically for misconduct in public office and obstructing an officer. Now, even though they're misdemeanors, these are very heavy charges when applied to someone wearing a badge. Misconduct in public office isn't just an administrative error. It speaks directly to an official abusing their power or position. potentially for personal gain or just to avoid accountability. And obstructing an officer means lying to investigators during the course of their official duties. Pretty straightforward.
And the sources make this comparison, which seems unavoidable. For the average person, you or me, facing clear evidence of lying to police or obstruction, charges are almost always filed, aren't they? The bar for probable cause was cleared here by the sheriff's own investigation team. They did the work, they found the evidence.
Exactly. The expectation, based on the evidence collected and the formal recommendation, was clear. Formal legal action should have followed. This looked like a pretty clear violation of official duty, documented by peer law enforcement officers. In a typical, functioning judicial system, that referral should have absolutely triggered prosecution by the DA's office.
But that's the critical accountability breakdown here, isn't it? The outcome from the DA's office. Despite the sheriff's formal referral recommending criminal charges for official misconduct, what actually happened?
According to the public records reviewed by the sources, nothing. No public records indicate that criminal charges were ever formally filed against either Rhines or Wooten by the district attorney's office. The charges were, it seems, quietly dismissed or simply never acted upon at all. So the DA, the ultimate accountability gatekeeper in the county, apparently chose inaction over enforcement, even on a clear finding of alleged criminal misconduct committed by public officials.
And the result of that non-action, what happened to the chief?
Chief Rhines was allowed to continue in his role as the village police chief, despite being implicated in orchestrating a lie to cover up a subordinate's patrol car crash.
That's astounding. It seems like an astounding failure of institutional oversight. He remained the leader, the supposed moral compass of a police force, even though he was directly tied to obstruction and dishonesty by an official investigation.
And the sources emphasized the complete lack of any public explanation for this decision from the DA's office, which only compounds the issue of secrecy and lack of transparency. Why weren't charges filed? Nobody said.
And then comes perhaps the most bizarre outcome of all this. Other jurisdictions apparently understood the severity of the situation, right?
That's right. Rhines ended up on Brady lists, those officer credibility lists we talked about, in multiple surrounding counties. Other district attorneys formally flagged him as untrustworthy for court purposes based on this incident.
Okay, wait. So other DAs, his peers in neighboring counties, put him on their list saying he couldn't be trusted.
Yes. And this is where the hypocrisy, or at least the inconsistency, of the Monroe County DA's discretion becomes really undeniable. Because other counties flagged him, the Monroe County DA's office itself was effectively forced into the position of implicitly acknowledging Rhines's lack of credibility. The sources confirm that Monroe County prosecutors actually stated internally, or perhaps to defense attorneys, that they would not rely on Chief Rhines's testimony to bring new cases to court.
Okay, let's be very, very clear about the position the DA's office created for itself here. They essentially declared the chief of police untrustworthy for judicial proceedings, meaning they couldn't vouch for his truthfulness in court. Yet, at the same time, they allowed him to retain his badge, his gun, his authority, and his command over his entire department.
That arrangement fundamentally compromises the rule of law, doesn't it? It demonstrates, or at least strongly suggests, that the priority was not necessarily justice, but maybe internal management, or avoiding conflict, or protecting fellow officials. The office appeared willing to sacrifice the integrity of the judicial process by openly acknowledging Rhines was unreliable for court, in exchange for avoiding the perhaps politically difficult task of prosecuting a local police chief for obstruction.
And this decision, this apparent shielding of officials from the consequences of documented misconduct.
That's precisely why the accountability situation in Monroe County warrants this kind of focused exposure.
And when you have that failure to charge, despite a clear referral for such flagrant dishonesty by officials, and that failure is accompanied by a total lack of public explanation, it doesn't really signal careful discretion, does it? It signals a preference for institutional secrecy over public transparency.
It certainly appears that way based on the sources.
All right, so if the enforcement failure in the Rhines case wasn't sufficient on its own to expose these internal operational integrity issues, we now turn to a separate and frankly highly ironic personal accountability test involving DA Croninger himself. Section 3 details his own hit-and-run incident.
Yeah, this incident provides a really fascinating and maybe uncomfortable contrast. Here you have the elected official responsible for prosecuting people who flee accident scenes, finding himself doing just that in December of that same period. It becomes a kind of litmus test, doesn't it? A test for whether the DA's own stated commitment to being not above the law applied equally to himself when the tables were turned.
Okay, so what happened? The event occurred in Sparta. Croninger crashed his vehicle into an unoccupied parked car, and then he drove away, leaving the scene of an accident, a hit and run.
Correct. And because the incident involved the sitting district attorney, the Monroe County Sheriff's Office took the proper ethical step. They immediately requested the La Crosse County Sheriff's Office from the neighboring county to conduct the investigation. That avoids the obvious and potentially damaging conflict of interest of investigating their own DA.
Okay, so La Crosse County investigates. What does their investigation chronicle about the timing?
The investigation notes the crash occurred, and Croninger did not report it immediately. He didn't call it in from the scene. He finally called the Sparta Police Department the next morning, December 30th, admitting that he had hit the vehicle the previous night.
Okay, that delay in reporting, that's critical, isn't it? For a couple of reasons.
Yes, very critical. First, according to the investigation reports, he told the investigators that he'd been drinking that night, although he claimed he didn't feel impaired at the time of the crash. But because he waited until the next day to report it, investigators were completely unable to perform any sobriety tests or chemical analysis to confirm or refute his condition at the actual time of the crash.
The consequences of that delay are pretty profound, legally speaking. If a regular citizen caused a hit and run, later admitted to drinking beforehand, and effectively prevented a sobriety test by leaving the scene and waiting until the next day, the potential implications for criminal charges, like OWI maybe, would be severe, wouldn't they?
Absolutely. The system lost a key piece of evidence, objective evidence about his sobriety, specifically because of that delay in reporting. Furthermore, Croninger admitted another violation during the investigation. He told the investigators that his truck windshield was frosted over that night, and while he apparently allowed it to warm up enough to see through the center, he admitted the sides remained obstructed.
Which, as the sources explicitly detail, is itself a violation of a Wisconsin state statute. There's a law requiring windshields to be kept reasonably clean at all times to prevent obstruction of view while driving. So, let's tally this up. We have an elected district attorney admitting to violating at least two key state statutes, leaving the scene of an accident involving property damage and driving with an obstructed view.
Correct. And this brings us directly to the consequences he faced, compared to the consequences his office refused to impose on Chief Rines and Officer Wooten. Croninger received a non-criminal traffic ticket for the incident, a citation. He paid the fine immediately. He faced a monetary penalty, not criminal charges.
He did issue a public apology afterwards, didn't he?
Yes, he did, saying he was deeply sorry and remorseful, admitting he knew he should have stopped immediately and reported it. And he included that phrase, that he is not above the law.
But that statement, it's just steeped in irony when we contrast it with his office's own actions in the Rines case, isn't it? He, the DA, receives a non-criminal citation for a hit and run, a situation where his own delay in reporting conveniently prevented a sobriety test after admitting he'd been drinking. Now, compare that outcome to the Rines-Wooten case. There, the sheriff's department completed a full investigation and concluded there was probable cause, a much higher legal standard than needed for a traffic ticket, to charge two officials with actual misdemeanors, including misconduct in public office, for deliberate dishonesty and obstruction.
Right. So let's be really explicit about the standard being applied here, based on these outcomes. For the DA himself, admitted misconduct and multiple statutory violations resulted in just a non-criminal fine, essentially a traffic ticket consequence. For the police chief and the officer, evidence reaching the level of probable cause for official crime, as determined independently by the sheriff's department, resulted in 0 charges. Nothing.
The disparity is just staggering. It's hard to reconcile.
It is. And it seems to confirm, or at least strongly suggest, that within Monroe County at that time, there appeared to be a kind of discretionary shield applied to officials, especially when those officials were part of the law enforcement or legal establishment. The message it sends, intended or not, is pretty clear. Consequences for those in positions of power are often discretionary and minimized, regardless of the apparent severity of the alleged offense or the constitutional duties they might have violated.
So the decision not to prosecute Rines and Wooten, which looks like a protection of the internal power structure, stands in incredibly sharp relief next to the decision to issue the DA himself only a non-criminal citation for his own admitted failure to stop and report an accident promptly after drinking.
The contrast is unavoidable, and it raises serious questions about equal application of the law.
Okay, let's try to synthesize these elements now as we wrap up. This deep dive has really exposed, I think, the significant and multifaceted integrity paradox within Monroe County, Wisconsin during this period. The structural flaw we discussed first, the discretionary Brady system created the opportunity, perhaps. And the enforcement failures we examined second seem to confirm an institutional culture where accountability wasn't always the top priority for officials.
Right. The sources really compel us to see this potentially as a pattern of systemic failure, not just isolated incidents. On one hand, we had that structural weakness, the loose Brady protocols, the high reliance on individual prosecutor discretion, and maybe a failure of leadership to implement mandatory compliance standards countywide. That system alone creating constant organizational risk for constitutional violations.
And on the other hand, we had the profound enforcement failure. Zero criminal charges filed for what was documented and formally referred to the DA's office as a clear violation of official duty. A police chief allegedly instructing a subordinate to lie and then obstructing the subsequent investigation.
And this confluence of failures, the systemic weakness combined with the specific enforcement breakdown, casts a pretty severe doubt on the integrity of the leadership at the time, regardless of any Prosecutor of the Year title. Accountability, it seems from these accounts, was perhaps actively managed to minimize disruption to the local power structure rather than being applied equally.
And the issue of secrecy you mentioned earlier feels paramount here, too. The failure to charge Rhines and Wooten, coupled with the complete lack of any public explanation for why those recommended charges for official misconduct were apparently dropped. It really signals a preference for opacity, for keeping things behind closed doors. The public was effectively shut out of the decision-making process on a matter of significant public interest.
Exactly. When the system fails to hold officials accountable for such flagrant, documented dishonesty and does so without any explanation, the damage to public trust is immense. It suggests, rightly or wrongly, that maintaining internal peace or maybe political stability within the local law enforcement community was deemed more important than the fundamental obligation to prosecute clear crime, regardless of who commits it. That decision alone, if that's what happened, severely undermines the public's confidence in the fairness and impartiality of justice in Monroe County.
Which brings us, I think, to the final necessary thought for you, the listener, to consider. Let's just compare the two main outcomes we've discussed explicitly side by side to grasp the true weight of this apparent failure.
Think about this contrast. On one side, you have a police chief and an officer. They were referred by the sheriff's department for criminal prosecution charges, including misconduct in public office, for allegedly fabricating evidence and obstructing an official investigation. Charges for this level of alleged official crime were dropped entirely or never filed with absolutely no public explanation given.
Okay. On the other side, you have the district attorney himself, the ultimate guardian of justice in the county. He crashed his car, he fled the scene, he admitted to drinking beforehand, his delay in reporting prevented a sobriety test, and he also admitted driving with an obstructed view, a separate violation. And he faced only a non-criminal traffic ticket and a fine.
If the system can operate in a way that protects officials who commit alleged misconduct in public office, seemingly at the expense of established probable cause, while simultaneously minimizing the consequences for the DA's own admitted violations and failure to follow the law, then the very foundation of fair and equal justice feels fundamentally cracked, doesn't it?
So, if recommended criminal charges for that level of official dishonesty, a police chief allegedly telling his officer to lie to investigators, can be quietly dismissed by a district attorney with no public reason given, what level of integrity can the public realistically expect from the institution supposedly safeguarding the rule of law in that community?
It's the question that really has to linger after reviewing these sources. How close is this kind of consistent, discretionary application of the law that appears to shield officials from consequences that would likely be mandatory for any average citizen? How close is that to institutional corruption? It certainly suggests an environment where accountability was selectively applied based on status or position. And that kind of system is inherently corrosive and demands ongoing attention and exposure.